Welcome to this employer compliance webinar on managing 90-day trial and probationary periods, presented by Employer Pro, empowering employers through effective people solutions. My name's Kent Duffy, employment law specialist and director here at Employer Pro. Employer Pro at a glance. Employer Pro protects employers through effective people solutions. We offer a cost-effective membership model with optional benefits. We have a suite of legally compliant employment documentation, from guidelines, webinars, walkthroughs, and templates for managing key employment processes. We offer employer-focused support, assistance, and representation. We assist employers to navigate workplace compliance and employment laws. In terms of an overview, this webinar on managing 90-day trial and probationary periods will be looking at the differences between a 90-day trial period and a probationary period, probationary periods and the importance of a formal process, correct 90-day trial period implementation, including the various compliance requirements that employers must meet when using 90-day trial periods, key legal considerations and risks, Employer Pro's resources for 90-day trial and probationary periods, practical hints and tips for 90-day trial periods. The starting point as an employer is understanding the differences between a 90-day trial and probationary period. There's a legal distinction between each of these two separate contractual mechanisms. They are not the same. Trial periods can only be used for new employees. A 90-day trial period offers superior protection and protects employers against claims for unjustified dismissal, which is largely the most common personal grievance claim in the event an employee is dismissed. However, the trial period must be implemented correctly. Where this applies and the trial period is valid, the employer is not required to follow any formal or fair process when terminating employment under a valid 90-day trial period, so it represents a far more effective option when terminating employment. Provided a 90-day trial period is valid, then the employer can terminate employment during the trial period, and the employee cannot raise, or they are precluded from, raising a claim or challenge by way of unjustified dismissal. They cannot challenge their dismissal is the short point. However, it's essential employers be aware that 90-day trial periods can be contested, which comes down to their validity requirements and whether the employer has met the various legal compliance requirements when implementing them correctly. So correct implementation is key. The various compliance requirements must be met when using a 90-day trial period. In contrast, a fair process or a formal performance management process for addressing performance concerns or substandard performance associated with an employee, or potentially a formal disciplinary process if the concerns associated with an employee who's employed under a probationary period is still required in order to justifiably terminate employment under a probationary period, which is distinct from a 90-day trial period. Employees who are dismissed under probationary periods can still raise personal grievance claims in respect of their dismissal, so claims for unjustified dismissal. This translates to mean that an employer's process in terms of managing concerns under a probationary period is key. The employer must have a sound and solid process before it issues a decision to terminate employment under the pretext or operation of a probationary period. Read Employer Pro's comprehensive ebook on managing 90-day trial and probationary periods for more information. Probationary periods and the importance of a formal process. Section 67 of the Employment Relations Act provides the law on probationary periods, which are an option to test an employee's suitability, whether they're a new employee that you want to try out, or perhaps a current employee who is, say, being offered a promotion and moving within an employer's business or operations. A probationary period must be specified in an employee's employment agreement. A probationary period does not affect the law relating to unjustified dismissal, so related claims can still be pursued, and this is the distinction in terms of the difference between a probationary period and a 90-day trial period. If a 90-day trial period is implemented correctly, again, an employee who is dismissed under a trial period cannot challenge their dismissal. In terms of a probationary period, the key is that a formal process must be implemented. under it to manage any concerns prior to terminating employment. So for example, if the concerns were around substandard performance, the employer would be looking to implement a performance management process or a PIP. Or if they were conduct-based concerns, then potentially the employer is going to be looking towards a formal disciplinary process, including warnings or dismissal on the basis of conduct-related concerns. Often a point of relevance to factor in or consider when managing concerns under a probationary period is that employers will implement a truncated process to manage concerns, so whether they're performance or conduct during a probationary period. For example, a formal process and an advancement, say, straight to a final written warning, rather than your usual process where if you're dealing with substandard performance issues or conduct-based concerns, often there will be a process that will precede it and numerous warnings before you can get to the point of implementing a final written warning. The key with these sorts of things is having good, thorough contractual mechanisms that spells out the process that the employer will follow to address such concerns when an employee is under a probationary period. Employer Pro has comprehensive specific clauses to this effect that can be used by members when utilising a probationary period. 90-day trial period implementation. This slide focuses on the various compliance requirements for 90-day trial periods, which must be correctly managed by employers in order to ensure that a 90-day trial period clause or arrangement withstands subsequent legal scrutiny in the event that it's challenged, or that the trial period is valid and remains valid, is the short point. So Section 67A and B of the Employment Relations Act 2000 provides the law on 90-day trial periods, which can only be used for new employees. That means employees that the employer has never previously employed before in any capacity. For example, say an employee who was previously employed by an employer, say 5 or 10 years ago, on the basis of a fixed term agreement, the employer would not be able to offer that person a subsequent job, whatever that looked like, whether it was permanent, subject to a 90-day trial period. That 90-day trial period would have to be removed, again, only for new employees. In terms of the other compliance requirements, the employer must have a legally compliant 90-day trial period clause in the employment agreement. Employer Pro has these sort of clauses, including the 90-day trial period, available for use with the compliant wording. The second point there is one that I've already spoke about, but again, can only be used for new employees. The employer must provide the person with a reasonable opportunity to get independent advice on the offer of employment, including the trial period before they start working. So it's essential to ensure that person has enough time to seek independent advice. Whether or not they choose to do so, a situation to avoid is don't issue a job offer on a Friday with the start date the following Monday. Why? Professional service firms like lawyers and consultants are closed during the weekend. So the effect of that sort of situation, which is somewhat common, means that if contested later on by a lawyer or an advocate, say, the person would be able to put forward the argument that they weren't provided with a reasonable opportunity to get independent advice before they started working. So always ensure that a prospective employee or candidate has at least about a week to get independent advice if they choose to do so. The other really important one, which is sometimes missed by employers, is that the person or the new employee must sign and return the employment agreement, including the 90-day trial period clause in it, before they start working. So don't allow a new employee to show up on their first day of work with an unsigned employment agreement. If that situation applies and they sign that contract subsequently, whether it's a minute or 30 minutes or a few days or a week after they start working, they're no longer considered a new employee for the purposes of trial period, and therefore the trial period is invalid. So something to be really conscious of as an employer when utilising these clauses or using a 90-day trial period clause. Always make sure you get the contract with the 90-day trial period clause in it back, returned, signed by the employee before they physically start working. The other requirements there is that 90-day trial periods can only be for a maximum of 90 calendar days, not working days, which is something to watch out for and not confuse, particularly when you're giving notice of termination. Bringing me to the second to last point there is that notice of termination must be managed correctly. So how notice is given, the operative notice period or length of notice period, including the options for managing notice. So for example, if the employee is required to work out the notice period, perhaps if there's contractual mechanism inside the trial period clause that allows payment for all or part or some of the notice period, the employer might look at doing that, or garden leave perhaps as well. These things need to be considered and managed correctly by the employer. And notice of termination must occur before the end of the 90-day period, which is again something to check before giving an employee notice of termination under a 90-day trial period. The final requirement there is that a 90-day trial periods cannot be used by accredited employers under the Accredited Employer Work Visa Scheme, which is for migrant workers. Immigration policy, or there have been changes to immigration policy, I think in 2023, which now preclude the use of 90-day trial periods in those circumstances for migrant workers or migrant employees. Key legal considerations in respect of 90-day trial periods. In summary, an employee who's terminated under a valid 90-day trial period cannot challenge their dismissal, but they can challenge the validity of the trial period. It is essential for employers to correctly implement the 90-day trial period. That is the key. Refer to the ebook that we have, step-by-step guidelines, the employer checklist, the sample termination letters, etc., that are available for use. The short point here in terms of these compliance requirements and the correct implementation is that the employer must satisfy all the various compliance requirements, or must get them correct when using the 90-day trial period. This is because 90-day trial periods are very strictly interpreted by the employment institutions, being the Employment Relations Authority and the Employment Court, and this is due to the severe or very detrimental impacts that they have on an employee's ability to access justice. So in summary, a trial period will either be valid or invalid. If valid, then the employee cannot pursue a claim for unjustified dismissal, or if they do, they will invariably lose that if the trial period is valid. Why? Because the 90-day trial period shuts the door or extinguishes, it precludes an employee's ability to raise that specific category or class of personal grievance claim. If invalid, on the other hand, if the trial period is invalid because the employee has not correctly managed the various compliance requirements that I spoke about, touched on broadly earlier, then this will risk exposure to potential remedies being awarded on the basis of a successful personal grievance claim for unjustified dismissal. So I'm talking about lost wages, injury to feelings compensation, or so-called hurt humiliation, legal costs, etc. So it's really important, again, that when using a 90-day trial period, that it is implemented correctly, and I cannot stress that enough. Check the resources out, tick the boxes, and check all of the various compliance requirements before terminating or when implementing a 90-day trial period. That is the key. By way of key legal risks, employers face exposure to personal grievance claims and other legal claims, and I touched about the remedies earlier in the previous slide, but things like lost wages, injury to feelings compensation, legal costs. You've also got potential risk of permanent reinstatement. That's where the employee goes back into their job, and other things like penalties, say for example, breach of good faith. Other practical risks include reputational consequences, because often cases are a matter of public record and they get reported on by the various news media outlets. And then practically you've got management time and the stress of dealing with litigation, which sometimes can be very immense and underestimated by employers. So these are all considerations to have regard to before terminating an employee's employment in any circumstances, particularly 90-day trial periods or probationary period contexts. In terms of Employer Pro's resources, we have a range of resources, tools and templates available to help employers, from comprehensive ebooks including step-by-step guidelines, concise practical employer toolkits and commentary for managing key employment processes, template letters and documents, webinars and training videos like the one you're listening to now, employment documentation, Employer Pro's employment agreements and templated workplace policies, along with access to further advice via advisory consultations and hands-on support via consultancy or formal terms of engagement if required. In terms of practical hints and tips for 90-day trial periods, always check the wording of your 90-day trial period clause and that it's legally compliant. Again, they can only be used for new employees, something to watch out for. And use Employer Pro's 90-day trial period and other templates related to 90-day trial period implementation. Those are on hand if you require additional information or tools and resources. Ensure any offer of employment, including a trial period, can only be accepted by signing and returning the employment agreement. Use the template letter in the resource pack or in the employer resource pack, which is marked offer of employment subject to a 90-day trial period. It has these sorts of caveats in it which are helpful and protect the employer's interests. Ensure the new employee is provided with the reasonable opportunity to seek independent advice on any offer of employment. Again, we recommend at least a week for this purpose. Ensure the new employee has never previously have worked for the employer before in any capacity before entering into the 90-day trial period. Also ensure, and this is a really important one that's often missed by employers, that the new employee signs and returns the employment agreement, including that 90-day trial period clause, before they physically start working. And again, read Employer Pro's comprehensive ebook on managing 90-day trial and probationary periods. Use the template letters and the documents that we have available. In terms of general disclaimers, this webinar is for guidance and information purposes only. It does not constitute formal legal advice. Employer Pro is not responsible for any liability or otherwise arising out of the use of this webinar. Seek professional advice from Employer Pro Limited by becoming a member today if further assistance or support is required. Employer Pro, supporting employers. Visit www.employerpro.co.nz or email info@employerpro.co.nz for further information or assistance.